Hello landlords, and welcome to the Landlord Advocates channel. You're here probably because you're having problems with your property or your tenants or both. Well, hopefully we have the solutions you're looking for. Let us begin with the COVID-19 virus. We know that this has been a problem and a situation for all people all over the world, and we understand and we're sympathetic and we're sorry for those that have suffered from it and those that will suffer from it. It's had a great impact on the planet. It's also had a great impact on you, the landlord, where you may have tenants who are out of work, not making any money to pay that rent that you're looking for. Some of them have the money to pay, but they're holding on to it because they're afraid they don't know where the next dollar is coming from. Or you may have tenants out there who are working, who have the money, but have decided that we're not going to pay because it's going to take a long time for you to evict us. What do they mean by that? As some of you may know, there have been moratoriums put on evictions all over the United States, from the state level down to the county, down to the local level. That moratorium is a time frame in which evictions will not be done, that the courts will not evict people, that the sheriff's department or the marshals will not put people out of their residence. Here in New York, where our office is based out of, it's a 90-day moratorium that took place on March 20th, 2020. That is where landlords cannot evict a tenant through the use of the sheriff's department or a marshal for 90 days. The big misconception out there in New York and everywhere is it means that the landlords are arrested from doing anything regarding removing their tenants from the property by starting the initiation on the necessary paperwork to get that tenant to move out. That is not the case. Evictions are unheard, but the processes to get to that point are not. That is from the advice of our attorneys here at Ideal Legal Support Services, located in Schenectady, New York. The advice that they shared is that the moratorium is on the enforcement of evictions, not the service of documents. Here in New York, the service of documents when a tenant doesn't pay rent is a 5-day notice, or what people perceive to be as a 5-day notice. That notice is given to the tenants after 5 days have expired in which they did not pay their rent. After that comes a 14-day notice to say you haven't paid the rent, please do so or move. After that time frame has expired, in a normal situation, the landlord would be able to acquire a court date to remove that tenant from the property. That is not the case here. The case here is that the landlord would serve the notices to the tenant or tenants. Make sure you serve every one, not just one or two. All the ones that are delinquent have to be served. Once that process is done, once they have been served those notices, it's a waiting game, waiting for the courts to reopen so that you can file for the eviction to get the tenant removed from the property. A lot of times when tenants will get that notice now, they will sit back and laugh and say that it's not legal. You can't serve me an eviction notice. La 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 la. Well, that's not the case. The notices that you are serving on those tenants by using a firm such as ours is a notification to them that they need to pay or move. That is not an eviction notice. It is not enforceable by the landlord. It is only enforceable to at a point where it gets to the court. It is a precursor to the point that it gets to court. Same as the 14-day notice to pay the rent. If at that 14 days your tenant does not pay, you cannot take it upon yourself to remove that tenant from the property. You can't change the locks on the door, you can't turn out the hot water, you can't turn out the utilities, you can't force them out. In a normal world, you would be able to go to the court and get a court date on that 14-day. Well, not now. Now you have to hold up and wait. But by doing those notices now, we'll get you further ahead to when the court opens. We can say, hey, listen, these tenants haven't paid, we want them to move. You'll get into court, the judge will make a decision, probably in your favor because the rent is still due. They still have to pay. And at that point, after the judge makes this decision, then the paperwork called a warrant of eviction is presented to the sheriff or the marshal. When the sheriff serves that notice on your tenant and finalizes the removal of your tenants, that is the eviction notice. Not the letter served by you or our office or any office similar to ours or an attorney is an eviction notice. Like I said, many tenants will laugh and dismiss any notice served upon them because they perceive it as an eviction notice, and it's not. Like I said, on the advice of our attorneys, that the notice served upon them is not an eviction, it is just a notice to let them know that they need to pay. Hopefully the information that I've just provided to you has opened up your mind and has made it more clear to you as to what a moratorium is on the enforcement of an eviction, but not the service of the documents necessary to lead up to that point. Hopefully this has been helpful, and if it has, we would really appreciate if you would hit that subscribe button and also hit the bell to let us know that you like what we have to say and that you want to hear more. There are many more videos coming. Every week we're looking to put a video out there to help you, the landlord, make better decisions on the property that you want to buy, the property that you own, the property that you want to sell, in relationship to the tenants that you have or the tenants that you wish to have them removed from the property. Until then, everyone, please be safe and take care.